started. It's a little after 3:30. I'm going to call this meeting to order. We will begin with requests for bill introductions. Representative Curtis has one.
I do, Mr. Chair. Thank you. I would like to request an introduction of 21 RS 0832. This is
Representative Curtis, can you unmute yourself again? We did a mute all, I think, in the room and lost you. I got all the way through RS 0832. Then we didn't hear what your bill's about.
okay, great. So this bill deals with expungement of certain records to be automatically expunged.
Yes, thank you, Mr. Chair.
This was a bill that was introduced last session.
Okay, Representative Curtis, time out 1 second. We started hearing a request for a bill introduction in another committee over our speakers. At least I think that was the case, unless you disguised your voice all of a sudden. So hold on. Okay, Representative Curtis. We got okay, now your hand's up. So now try to unmute yourself again. And we heard most of it. So just kind of your wrap-up pitch.
This bill deals with is for auto expungement, and it is the same legislation that was introduced last session by several members of this committee.
Awesome. Any questions, committee? Any objection? Don't see any, so it will be introduced. Any other requests from the committee? I have one on behalf of both the University of Kansas and Kansas State University. It's RS 0891. It's dealing with the use of student athletes' name, image, and likeness. Any questions? Any objection? See any, we'll get that introduced. No one else on the committee. Anyone else here today with a bill request? Okay, we will move on. 2 bill hearings today. I'm going to open the hearing on the first one, HB 2120. And we'll throw it to Natalie for an overview of what the bill's about.
Thank you, Mr. Chairman. House Bill 2120 would remove the spousal exception in sexual battery. So the bill amends KSA 215505 to remove the qualification that the victim is not a spouse of the offender for the crime of sexual battery. I would just note down in subsection B, it looks like we're making a change. That's actually just technical cleanup because now the crime of sexual battery, now that spousal exception will be removed, aggravated sexual battery will just be the crime of sexual battery under those certain circumstances. So I just wanted to point that out. It looks like a bigger change, but it's really just technical. And I can take any questions.
Any questions for Natalie? Natalie, before Representative Carmichael asks, have we seen this bill before?
Yes, you have. Gosh, I was like out of practice. The last couple hearings weren't new ones. You actually heard this a couple years ago. It was House Bill 2079. Just last year, I believe. Let's see. It was House Bill 2467. And you guys heard that bill. It passed out of this committee. There was a floor amendment to add the provisions of a different bill. And then it passed your guys' chamber 105 to 15. And then it went over to the Senate Committee on Judiciary where it died in committee.
Thank you. So questions for Natalie. Representative Curtis, is your hand up? It's not up. Okay. Representative Carmichael?
Ms. Scott covered my question.
Sorry. Look at that. I cut you off, so you have time for more questions. Representative Sampson.
Thank you, Mr. Chair. My question, it may be for Natalie, it may be for the proponents, but can you help me understand what the status of the law is right now under this situation if this change were not to be made?
Mr. Chairman, so right now, under the current sexual battery statute, you'll see that it's impossible to commit a sexual battery against your spouse. So the elements of the crime are touching the victim 16 years of age who does not consent thereto with the intent to arouse or satisfy the sexual desires of another. But if you happen to be married to that person, then that action doesn't rise to the result of a violation of this crime. And so this would make it so you can, if someone were to engage in this conduct with their spouse, it would fall under the purview of this crime.
And so maybe a better way of me phrasing my question, say the same bad act, the current law is as it is status quo, that person would then be charged with what? Just a regular battery charge?
Maybe it's possible that they could, I mean, it depends on the circumstances. It's possible that they could be charged with regular battery. But this crime covers any touching without consent with the intent to arouse or satisfy the sexual desires of the offender. That language doesn't appear in simple battery. I would have to go look at just simple battery, but.
Well, thank you. And with the chair's permission, part of the reason I'm curious is in some ways, although it doesn't seem like it at face value, it has some parallels with a very common problem we have across Kansas that's also near and dear to my heart in the officiating world. And I'm frequently told, well, just use the current assault and battery laws, but they don't really work that well for a number of reasons, which is why a couple of other representatives and I who have passions, either spouses or kids who officiate in our schools and youth events, but we've looked at a bill that's targeted at harassment or abuse is probably the better word actually of specifically sports officials. And so I'm intrigued to hear from our proponents and perhaps others, but how this bill by doing this change really does help more in this specific scenario with spouses by making this change in the law as compared to existing law. So I appreciate your information there. Look forward to hearing from the proponents and others. Thank you, Mr. Chair.
And
Hoheisel.
Mr. Chairman, just one more.
Yes.
I just went over to the definition of battery just for reference. So that would be either knowingly or recklessly causing bodily harm to another person, which, that's a little bit different. The second element of battery is knowingly causing physical contact with another person when done in a rude, insulting, or angry manner. So the difference is there, I guess, is the intent of the offender, whether you are doing that in a rude manner or whether you're doing it with the intent to satisfy your sexual desires.
Thank you, Natalie.
Representative Hoheisel.
Thank you, Mr. Chair. Thank you, Natalie, for that breakdown. Do we currently have any other spousal exceptions on the books for sexual crimes?
No, not anymore. We have, and throughout history, but those have all been removed except for here in this crime.
Thank you, Mr. Chair.
Representative Carmichael, is your hand up? I mean, I see it up online, but
yes, thank you, Mr. I didn't mean to. A question for the reviser. My recollection was that battery is when it's done in a rude or insolent manner. Has it now been changed to insulting manner?
Yes, Mr. Chairman. So KSA 215413 is our battery statute. And so subsection A2 reads knowingly causing physical contact with another person when done in a rude, insulting, or angry manner.
See, I learned something every day. Thank you, Mr. Chair.
Any other questions for Natalie? Representative Wheeler?
Thank you, Mr. Chair. Natalie, as this is amended, it says with the intent to arouse or satisfy the sexual desires of the offender or another. Could that another be construed to also include the purported victim?
Mr. Chairman, that other person could be the purported victim, but I would note that it says who does not consent thereto. So it would be action, I guess, that the offender was taking maybe in an attempt to satisfy the person's sexual desires, but it's action that's taken without their consent.
Don't see any other questions. We will move on to proponent testimony. The first one, which is online, is Julie Donnellan.
Thank you. Chairman Patton and members of the Judiciary Committee, thanks for allowing me to provide testimony on this important bill. As you mentioned, my name is Julie Donnellan, and I'm the president and CEO of MOXA, the Metropolitan Organization to Counter Sexual Assault. I've worked in the field of sexual abuse and assault for over 25 years. On behalf of MOXA, I'm testifying today in support of House Bill 2120. MOXA is the only rape crisis center that serves Johnson and Wyandotte counties in Kansas. Our mission is to improve the lives of those impacted by sexual abuse and assault and to prevent sexual violence in our community, the bi-state Kansas City metropolitan area. MOXA provides advocacy and counseling services to individuals and families who've been impacted by sexual violence, and we work to prevent violence through our education, prevention, and outreach programs. We see firsthand the impact that public policy has on our community in survivors' experiences as crime victims, as well as the societal norms that guide how we respond to sexual violence. It is with both these things in mind that I express my gratitude for the committee's consideration of this bill. The policies and statutes that govern the criminal justice system in Kansas reflect our priorities and values. This proposed change to statute is simple and it's long overdue. House Bill 2120 will remove what is known as a spousal exemption from the elements of the crime of sexual battery. The importance of removing this language is both practical and symbolic. Passing House Bill 2120 sends a clear message to Kansas that violence is no less harmful when it happens at the hands of someone the victim loves and trusts. It sends the message that the state of Kansas has a vested interest in ensuring that our citizens are safe in their own homes. I believe this is a message that truly represents our values and our priorities. As a society, we have made so much progress over the last 50 years in our understanding of sexual violence and our work to support victims and hold perpetrators accountable. Part of this work has been to break through the myths and misconceptions about sexual violence and share light on the reality of the problem. We know that sexual assault is more likely to be committed by someone that the victim knows, according to the Rape, Abuse, and Incest National Network, or RAINN. About 33% of assaults are committed by an intimate partner. We have removed spousal exemptions from almost all sexual offenses in our state, and we are proud to support this legislation to remove this remaining vestige of the past. Thank you for your time.
Committee, we will do questions at the end of each segment of proponents, opponents, and neutrals. Next, we've not seen her for a week or so. Sarah Russ Martin's back to join us.
Thank you, Chairman Patton. Members of the committee, thank you for the opportunity to be here today with proponent testimony on House Bill 2120 that would eliminate spousal exception to sexual battery. I'm the Legal and Policy Director at the Kansas Coalition Against Sexual and Domestic Violence. We are comprised of the 26 domestic violence and sexual assault advocacy programs that cover all counties in Kansas, including MOXA, which was shared with you a minute ago. Although marital rape, a question that came earlier is this the only spousal exception left on the books? It is. As of 1993, all states in the U.S. had criminalized marital rape. But we are one of a handful of states, and just a handful, that have allowed exceptions for sexually based crimes when the offender is the spouse of the victim to continue. This archaic thinking dates back to common law when women's unconditional sexual consent was considered part of the marital contract. If we allow the spousal exception to continue, we are memorializing and honoring a belief in a system rooted in disenfranchisement, violence, and misogyny. There are other statistics stated in my written testimony, which I won't read to you, but we at the Coalition and our 26-member programs again ask for the passage of House Bill 2120 and removing the spousal exception to sexual battery. Thank you, and I'll stand for questions.
Thank you. I do not show any other proponent testimony. Is there anyone here or online as a proponent? Come on up.
Good afternoon. Did everyone hear me okay? Okay. Good afternoon, members of the Judiciary Committee. Thank you for your consideration of House Bill 2120. My name is Mary Stafford, and I am a licensed master social worker who has spent over 10 years advocating on behalf of domestic violence survivors in Kansas. This is the third consecutive legislative session I have appeared before the members of this committee to voice my support for removing the spousal exception in the sexual battery statute. I ask you to grant this bill the urgency it is due by enthusiastically supporting its advancement in the legislative process. The Kansas Bureau of Investigation indicates there were 22,453 reported incidents of domestic violence in Kansas in 2019. Additionally, a study from the National Institute of Justice and the CDC found that only 25% of domestic violence incidents are reported to law enforcement. Therefore, we can only speculate as to the true number of our fellow Kansans who have been on the receiving end of intimate partner abuse. Unfortunately, sexual violence is all too commonly used as a control tactic within abusive relationships. The National Coalition Against Domestic Violence reports between 40 and 45% of women are sexually assaulted by intimate partners during their relationship. It is important to note, however, that percentage only reflects the number of women who identified their experience as sexual assault. It does not account for the multitude of women who are sexually manipulated, coerced, exploited, or abused by a partner, but are reluctant to identify it as an assault. Nevertheless, when we consider the information provided by NCADV in conjunction with the statistic about underreporting, we can logically conclude that thousands of our neighbors, our colleagues, our friends, our family, and our community members are affected by sexual violence within an intimate relationship each year. Domestic violence is fundamentally rooted in elements of power and control. Perpetrators use a variety of physical, emotional, financial, and yes, sexual tactics to dehumanize their partners and make them feel they're not worthy, deserving, heard, or believed. We add validity to perpetrators' tactics and further delegitimize survivors' experiences by allowing a spousal exception in the sexual battery statute. Kansas has long since recognized that rape within the confines of marriage is a crime, and it is past time to establish the same for sexual battery. Permitting the statute to remain as currently written sends a message to perpetrators that they can sexually violate their partners and will not be held accountable. To the contrary, House Bill 2120 sends a clear message to survivors that they are entitled to bodily autonomy, sexual boundaries, and safety, and that a marriage license is not a forfeiture of their basic human rights. I ask you to join us in creating a safer and more just Kansas by restoring dignity to thousands of survivors, ensuring a fair and equal balance of power within marriages, and supporting House Bill 2120. Thank you for your time. I'm also happy to stand for questions.
Very good. Anyone else here as a proponent? Okay, committee questions. First up is Representative Samsel.
Thank you, Mr. Chair. For any of the proponents, if they would, I read in the testimony and I understood the testimony as to how this would send a symbolic message. But could one of them please help me understand what the practical impact of this would be if we were to pass this law as they've requested? And to maybe help ask a little bit better question, how does this improve? Like, we've got battery laws on the book, right? When I read the battery statute, it seems like that law could be used to go after the bad actor with all good reason and hold them accountable that way. What is the practical benefit of removing the spousal exception that's been requested here.
Well, this is Sarah Russ Martin with the ks.gov, and the practical piece of this. You're right, Representative, in terms of the fact that domestic battery, for instance, we read the simple battery statute at the beginning of the hearing, but domestic battery is simple battery done within the context of that the sort of required relationship, right? So would this potentially, if this were done within a marital context, could it potentially be touching someone in a rude, angry, or insulting manner that then could lead to the charge of domestic battery, potentially? But there are several crimes, I think, on the books where we could decide which crime best fits the conduct. And in this case, what we're talking about is not just a touching of someone, but a touching of someone done without that person's consent and for the sexual gratification of the offender. And if that happened in a relationship where, as Mary quite eloquently said, happens a lot within domestic violence relationships where sexual violence is also used, they would have to find another statute in order to charge this person, because they could not be charged with sexual battery simply because they are the spouse of the person. And that's the piece that seems wrong. The conduct's happening today in our communities and in people's homes. It's just not able to be charged.
Thank you. Quick, with the chair's permission, a follow-up on that, and hopefully to put a positive spin on this, but I was going through my briefing materials from last year and came across, I believe it may have been from a college student, a couple college advocates that came and before COVID were allowed to walk through our buildings. And it wasn't so much of the, I don't know how to properly phrase it. It's not that they didn't say no, but actually having them affirmatively say yes to give affirmative consent. And I'm not saying that needs to go into our statute here or any other context, but it does seem like that's a much better public policy in many ways. And maybe not with the spouses, maybe it is. But if you actually have somebody say yes, instead of them just remaining silent or they're asleep or whatever else is going on, is there a way as the state we can put that into statutory language to say, before you engage in sexual conduct, you better have had the other person say yes? I remember back in my college days, our towards counselors used to say, you better get a notarized note from their parent before you do anything that might turn out bad later. And I don't know that that's real practical, if you will. It might be symbolic, but nobody was going to get a notarized note from their mother. But if you actually had the other person say yes before we got into this stuff, it seemed like it would prevent a lot of this, what is a very serious problem in the spousal relationships, very serious problem on our college campuses, and the very real impacts of it. I have kids from around this area and their parents who, because the other person, they drink a little bit or what, it doesn't matter, but they did not say yes before they engaged in it. And then we don't really need, it takes little imagination or research to figure out the wealth of problems that then our college campuses and many others are dealing with that really aren't education related issues, but the life of college students and their parents and maybe spouses and everybody else that's getting involved in there. So that would, I just throw that out there, food for thought. No particular objection to the language we have here, but it seems like if we really are going to update our outdated statutory language in some ways, maybe there's even room to go a step further. So I welcome any comments from proponents on that.
Thank you. Again, it's Sarah. If either of the other proponents would like to speak, just push me aside. But there are other states that have done exactly that. They have passed affirmative consent laws in their states. That is sort of best case scenario for those of us who work in the sort of world of sexual violence, because we believe that that is the clearest form of consent, is to be sure that you did receive consent. So we would be happy to work on language or pull together some samples from other states or whatever we could do to move that forward if the time comes when that is a serious consideration.
This is Mary Stafford, and thank you, Representative. I would just contribute that you will never hear a domestic violence or sexual assault advocate worth their salt tell you that we don't want affirmative consent. Yes, we want affirmative consent, and you would have dozens of people across the state who would enthusiastically work with you on drafting that. As Sarah said, other states have implemented it, and it's certainly something I think to strive for. Another thing to consider when we're discussing consent within the confines of an abusive relationship is that it gets a little bit more murky because a victim may not ever try to fight the perpetrator off, may not scream no, may not give indications that would otherwise allow a partner to know that their advances are unwanted, simply because they're not safe to do so. And so, yes, absolutely, affirmative consent is the gold standard in our field and something that we would hope to strive for. But just being mindful that in the confines of domestic violence, when there's an ongoing pattern of abuse and control and dominance by one partner, that can complicate matters in terms of just objective yes, no consent.
Thank you. Mr. Chair, I do have one more question, but I'm monopolizing the time, if time permits, Mr. Chair, but otherwise I yield the floor. Thank you.
Representative Heiberger.
Mr. Chair, I just want to point out that one other difference between the two crimes is sexual battery is a Class A misdemeanor, regular battery is a Class B.
Any other questions? If not, we'll give Representative Schreiber.
Thank you, Mr. Chairman. This goes back to the earlier representative's question on the phrase "or another." Would this? I always think of battery as, I guess direct person to person and so forth. But with "or another," would that allow, or would this be a crime if someone posted something online that of this touching? Or is that covered under another statute? I'm not familiar with that, but just a follow up from Representative Wheeler. Thank you.
Natalie, do you want to take a shot at this one?
Sure. Thanks, Mr. Chairman. This crime actually requires actual touching of a person. So posting something online, like a picture or something like that, we do have statutes that cover that. In certain circumstances, breach of privacy covers that in certain circumstances. But this crime requires actually touching a person.
Okay, I think that was the intent. The wording just seems a little odd because it says satisfying the sexual desires of the offender or another, which I guess could be someone online. But if there's other statutes that cover it, that's fine. I was just seeing if this one covered that as well. So thank you. Thank you, Natalie.
Other questions? I'm going to let Representative Samsel ask another question, but this is a good chance to remind everybody, especially in the coming days as our bills are going to get more controversial, that we're going to do the two questions. Let's give everybody else a chance, and if we have time, we'll come back to you, rule that we had last year. So Representative Samsel.
Thank you, Mr. Chair. Hopefully this is a narrow one for the proponents, but it really gets to my heartburn with this bill. And certainly it looks like many states have recognized good public policy to get rid of spousal exceptions. But it does seem like the spousal relationship in many ways is a special relationship. So my heartburn comes from when I read this language, and if we get rid of the spousal exception, that it seems like a very easy standard for somebody to say that this did happen. And I don't know if that's right or if that's wrong, depending on the marriage and the contract and your religious beliefs and all the rest of that stuff. But the practical side of it to me is it seems like when unfortunately in our society, many of these marriages go bad and then they end up in divorce or all of the other, terrible outcomes. My heartburn comes, and if you can speak to this maybe to alleviate my heartburn, and it's not to say that the actions were right, but the potential for mischief, if you will, after a marriage goes south and divorce and anything else that follows. But that seems like a very tough standard after the fact to say, well, he or she touched me without my consent. That seems like that might happen. I don't know how regularly in the marriage context, but I don't know. That's where my heartburn comes from. So if any of the proponents want to speak to that, otherwise we can save that for when we work the bill.
Well, this is Sarah again from ks.gov, and the point that I'll make here is that, I completely agree, Representative. Thank you for pointing out that the marriage relationship is unique to all other relationships. But we do have a domestic battery statute where we say that because of this relationship that you have oftentimes a marriage or an intimate relationship, and some sort of angry, rude, or insulting touching happens, then the person can be arrested for domestic battery. And yet in the sexual context, same concept, we're saying, no, we can't go that far. So I believe that in order for us to sort of move beyond that sort of fear-based place that people are going to run rampant with this statute, I don't see that happening around in the domestic violence context. I don't necessarily see that happening around this context. But law enforcement is going to have probable cause, just like in any other crime. It is not just the saying that will result in charging. So I think that's the piece that we have to, at least from my perspective, be mindful of.
This is Julie Donnellan with Moxa. I would just like to reiterate what Sarah Russ Martin said, that that first of all, to have a crime that's committed by somebody outside of the marriage be qualified as sexual battery, but not to have that also allowed by somebody within a marriage, I think is contradictory and does not show the importance of the value in that marriage and the relationship, that special relationship of that marriage, that it should be consenting activity within a marriage and outside of a marriage. And then secondly, to Sarah's point that an investigation would have to be done and this would need to be proven. And so I don't think it's going to, and we haven't seen in other situations when the spousal exemption has been removed, that this is something that's running rampant with allegations being made about rape and assault within the marriage context.
And this is Mary Stafford. I will echo what my two colleagues have said and again reiterate that domestic violence and sexual assault are two of the most underreported crimes in our country, and especially that's true in the state of Kansas. And so while yes, it is absolutely possible that someone might make a false allegation, I would encourage you to consider all of the thousands of people who are currently experiencing this and not coming forward. And we could speak in speculation and what ifs and all of those things. I would also encourage us to keep our focus on the very real lived experience of thousands of Kansans that we know and love and care for who are already experiencing this every day.
Thank you, Mr. Chair.
Not seeing any other questions. Is there anyone here today as a neutral conferee? Anyone as an opponent? Not seeing any. Closing the hearing on House Bill 2120. We'll now open the hearing on House Bill 2095. And we will have Natalie share a little bit of information about the bill.
Thank you, Mr. Chairman. House Bill 2095 allows a court to prohibit possession of a firearm in temporary custody orders pursuant to the Care and Treatment Act for Mentally Ill Persons. Section 1 amends KSA 592959 to provide that sort of temporary custody order, which would be issued pursuant to that section, can prohibit a person from possessing a firearm and require that person to petition the court to reinstate their right to possess a firearm. If that order is issued by the court, then the court would be required to direct the clerk to send a copy of the order to the KBI within 5 days. And the KBI would have to enter that information into the National Criminal Information Center and other appropriate databases. And the court would also have to notify the person named in the order of their right to petition the court to reinstate their right to possess a firearm. Section 2 amends KSA 592966. That is the statute that provides for the final orders. And it would provide that the court would have to notify a person named in the order of their right to petition the court to reinstate their right to possess a firearm. And I can take any questions.
Do we have any questions for Natalie? Representative Burris?
Thank you, Mr. Chairman. Natalie, I'm wondering how many processes are provided for, or provided for in Kansas statute for determining someone is mentally ill?
Well, for purposes, it kind of depends on what purposes that you're talking about. So, I mean, there's obviously a different proceeding that one would undergo for like competency to stand trial, for example. But this set of statutes, this act is the Involuntary Commitment Act. So we're just talking about orders that are issued pursuant to this particular act.
Thanks for that clarification. One of the reasons why I ask is because it just seems from the material on page 2, lines 2 through 19, the process for this determination. Well, I mean, the word informal is used, and I'm just concerned that this process could, or a determination could be made on the basis of, well, in other words, it's not a very rigorous process. Would that be correct?
Well, and let me kind of clarify, there are kind of 2 steps to this process. First, when this petition is filed, the court has the ability to enter a temporary order. So that would just be like a really quick order while they are waiting to have an actual full-blown hearing on the merits of the petition. So the changes in the first statute here, which would include the language that you're talking about on page 2, that is all part of the temporary order process. And then after those orders are entered, then it goes through a more complex, formal hearing process on the merits of the petition.
If I may, Mr. Chairman. Just to clarify, on the basis of a temporary order, I mean, a person's, firearms are, the order is saying just on the temporary order, nevertheless, does say that they cannot possess firearms. Is that correct?
That is what the bill is proposing to do. Yeah.
Thank you, Mr. Chairman.
Representative Wheeler.
Thank you, Mr. Chair. Natalie, I don't see in this bill, if I'm reading it correctly, it does say that a temporary order can be entered.
Sorry, Representative Wheeler, I'm having a hard time hearing you. Can you?
Okay, it does say that may I, Mr. Chairman? It does say that a temporary order can be issued that the person cannot possess a firearm. I see nothing in this statute that gives the authority of any law enforcement agency or anyone else to seize the person's firearms. Where is that found?
Mr. Chairman, Representative Wheeler would be correct here. That language is not included, but there are different statutes, and I will have to find, unless Scott or Jason knows them off the top of their head, there are different statutes where someone who is not legally authorized to possess a firearm, there's a process by which law enforcement can seize that firearm if they're found to be in possession of it.
I'd like to know the other statutes. When
I'll look into that.
I appreciate that. Now, going back to the definition of mental illness and going in further to a person subject to involuntary commitment for mental illness, which I am referring to KSA 592946, section F1. It specifically excludes alcohol, chemical substance abuse, antisocial personality disorder, intellectual disability, organic personality syndrome, or an organic mental disorder. Cannot be committed involuntarily or mental illness under our mental illness code. There are other provisions for committing an alcoholic, isn't there?
Yes, Mr. Chairman.
treatment.
Well, they have their own separate act, which is, so we're in Article 29 of Chapter 59. For people with a substance abuse problem, they are covered in Article 29B of Chapter 59. So that's the Care and Treatment Act for persons with an alcohol or substance abuse problem.
And I'm not asking you to make a value judgment, but I'm suggesting that people who are suffering from acute alcoholism are also may be dangerous to oneself or others. Isn't that correct? Well, I'm not going to ask you that.
Thank you.
But I'm proposing that from experience. And the same is true with several of these orders that are not subject to commitment for mental illness. But for those people, we don't seize their firearms, do we? There's no specific provision that when you file for a treatment on a substance abuse, be it alcohol or drugs, there's no provision that their firearms be seized.
Mr. Chairman, I'd have to look for sure to verify that in both the Alcohol and Substance Abuse Act and probably also the Sexually Violent Predator Act, which is similar there. But so I don't know that off the top of my head, but I can look that up.
Thank you. I appreciate that, Natalie. Thank you, Mr. Chairman.
Representative Owens.
Thank you, Mr. Chairman. And Natalie, thank you for being so smart. We rely on you immensely, and we're really grateful for your dedication to the work that you do here for us in Judiciary as well as corrections and other areas. This sounds similar to a protection from abuse order, where you have a bit of a kind of an informal hearing, judge chooses to issue it. Can you tell me if the same applies in a PFA, if somebody loses their right to possess a firearm prior to the due process hearing that occurs 30 days later?
Mr. Chairman, let me, so those, I'll try to find the exact citation for you, but those temporary orders, I don't know that it says one way or the other. So there are lots of things that are included in that type of temporary order that's not necessarily listed in the statute. So I'm not sure if a judge ever orders that in that type of case, but I can look into that further.
Thank you. I appreciate that.
Any other questions for Natalie? Representative Wheeler?
It just occurred to me, and a person is subject to seizure of his or her weapon under this statute as proposed under the temporary order. What if that weapon is owned by another household member?
Mr. Chairman, I think in that case, you would have to rely on the definition of possession if that person were then charged with illegally possessing a firearm. So I think that that's the context in which it would come up if someone was alleging that they were possessing a firearm without legal authority to do so.
In my circumstance, the wife, I'm going to use the wife, goes down to the gun shop, has a background check, and purchases a 9mm, and it's in the house of the proposed patient, of the patient. Do they seize that weapon of the wife?
Yeah, Mr. Chairman, I would have to kind of look at, so this bill doesn't get into the seizure process or taking the firearm away. It just is an order that says any person subject to this order, it's, no longer has a right to possess a firearm, until the final determination is made at the final hearing. So it doesn't really get into like the seizure of that firearm or what happens as a result of that. So yeah, I'd have to look into that a little further to see how that works.
Appreciate that, Natalie. I know that this bill doesn't specifically use it, but it impacts the other statutes that may cause a person to lose their possession of their own firearm.
Not seeing any other questions. Oh, I see one now. Representative Owens.
Surprise. What is, based on what Representative Wheeler's asked, it makes me wonder what the definition of possession is. Is that on one's person? Is that in one's vehicle, in one's house? Or how do we define possess? Throwing a lot at you today, Natalie. Thank you.
So, Mr. Chairman, now what I'm going to read you is for purposes of the criminal code. So if there was some type of crime that they could be charged with, that, you know, that may not necessarily be the circumstance in which it comes up. But for that purpose, possession means having joint or exclusive control over an item with knowledge of or intent to have such control, or knowingly keeping some item in a place where the person has some measure of access and right of control.
Now, not seeing any additional questions, we'll move on to proponent testimony, and we will start with Scott Schultz. Welcome to the committee, Scott.
Mr. Chair, good afternoon. Members of the committee, can you hear me okay?
We can.
Thank you, Mr. Chair. I would recognize that the answer to the one of the other first questions for me will be no. The other conferee, Todd Thompson, and I did not coordinate outfits today. So with that, I will go ahead and continue. The Sentencing Commission is, I'm representing the Sentencing Commission, obviously, and on behalf of them, we are bringing this particular bill to you. There was some concern by some of the judges that brought it to the commission for discussion. And this centers around, as Natalie has talked about, the temporary custody order that is done in care and treatment cases. These are involuntary committals in which individuals are usually contacted by, law enforcement gets a call, they contact the individuals, and they may, again, detain the individuals. And at that particular time, then a community mental health individual will actually assess the individual, and then the temporary hearing will actually be set. At that particular hearing, the judge will receive evidence as to whether or not the individual, there's probable cause to believe the individual is a danger to themselves or others. And court will also receive testimony a lot of the times from that community mental health individual as to his or her assessment of that individual. If that actually occurs, then the court can enter a temporary order to detain that individual and send them for further evaluation. They usually go to Osawatomie or Larned State Hospital. The part that we obviously are talking about today, they're sent to the hospital, and then another trial. The trial itself is actually set for later. The gap that we're talking about here is what the concern is, because many of several of the judges that we talked with indicated that once that temporary hearing actually happens, they go to Osawatomie, for example. They're brought in, stabilized, put back on their medication, for example, and at some point, Osawatomie will actually release them back to their homes prior to the trial. And in many cases, the trial never actually happens. And so there is a public safety concern during that particular time when, after the district court has found sufficient evidence that there's probable cause to believe that the person's mentally ill, that we believe that the possession of firearms order could go into that temporary order. I also listed in there with regard to officer safety. Part of this is once that temporary order would be entered, the clerk would send it to KBI. KBI would then have 5 days to enter that into NCIC or the National Criminal Information Center, which is the national database that indexes criminal actions. So, so then officers, if they contacted that individual again, would know that there would be that particular order in place. In speaking to, I think, Representative Wheeler's questions, that I don't know that the commission at all would be objecting to some sort of procedure that would instruct further law enforcement on how to actually take those, a seizure provision or something of that nature. This particular section was simply speaking towards the process by which the court could enter a temporary order that would do that. I think on the backside, certainly, if that individual were to violate an order, they certainly would be subject to contempt powers of the court as well. Finally, I would just conclude with, I believe that Mr. Thompson's tie is nicer than mine. And with that, I'd stand for questions at the appropriate time.
Got Todd, welcome back. I'll jump right to you.
Thank you, Chairman. I was having some audio problems, or I'm hoping everyone can hear me. Is that happening?
That is happening.
If not, I'll just talk through Scott. I know we kind of look the same today. So I appreciate the opportunity to be able to present. This is a very important bill. I'm presenting not only on behalf as the Leavenworth County Attorney, but also as a member and board member and past president of the Kansas County District Attorneys Association. Our board has found that this is a very important issue. As Scott was kind of going over the process of this, what generally happens for a care and treatment case is there will be a temporary or a custody and then a temporary hearing. At that temporary hearing is where we're asking that this implication of the possession of the firearm take place. What we have found, just as Scott iterated, is that what happens is many don't get to the adjudication, therefore that they're still possessing or still able to possess. And this is one of the most, this is the time that it's most valuable to have them probably not have a weapon. If you're not familiar with the care and treatment case, I know Representative Wheeler is, these, for sure, these are cases where people, where county attorney's offices have to look into prosecuting, not prosecuting, but it's a civil matter, but doing cases where a person who is a care and treatment is a harm to self or others. As I said in my testimony, of the cases, of the 26 we saw last year, 10 are actually criminal cases, and one had just been released from Lansing Correctional Facility for a second-degree murder. It's a very scary time for them to be able to have a weapon until they can get under control. And that's why it would be very important to have them at least without a firearm at this point in time until they can come back before the court and either have their adjudication or say to the court that, and show to the court that they're capable of being able to have a firearm. Doing that, like I said in my testimony, we've had cases where family members as well as the other people are very concerned about the safety of those that have been found to be a care and treatment. It is not an easy process at all to be able to find, and it is one that I think is very important for us. As Representative Wheeler mentioned about several other circumstances in which people should probably not have firearms, I don't have any disagreement, but I think for the purposes of this statute, I think fundamentally for the safety of our community and for the individuals themselves, it would be very important. I stand for any questions.
Committee, we have one more proponent, at least that I know of, a written proponent from the American Academy of Pediatrics that's been emailed out and posted online. Is there anyone else here as a proponent? Don't see any. We will move to questions. First on the list is Representative Carmichael.
Thank you, Mr. Chairman. A question for Mr. Thompson, if I could. I may have misunderstood you, but I thought you gave us an example of someone who had been released from Lansing on a second-degree murder charge and suggested that this type of legislation was necessary to deal with a person in that circumstance. My recollection is that felons are disqualified from possession of firearms and that it's a felony to be a felon in possession. And I can't remember how long it is before that disqualification goes away. Why would that circumstance be relevant to this bill?
I don't know if it's exactly relevant. It's just a circumstance in which there is a person who has care and treatment, and something that would be an effect that an issue that we would also note that would be further reason why this amendment to this statute would be important. You're correct that a felon in possession of a firearm is also a count and probably would be similar to what you might look at filing a charge for something like this. So an account, yes, you are correct. I don't know that they're allowed to possess a firearm, but if it's something that if they get a care and treatment that we could reiterate to them that they should not be having a firearm and make sure that not only they but the people around them know that beyond just the fact that they are a felon on supervision. And there are cases where people do get off parole, but usually I think there is a waiting period which they can't have a firearm, which is generally 5 to 10 years.
Representative Owens.
Well, I'm still having difficulty figuring out why this is necessary in the context of convicted felons, presumably on parole, but I appreciate your answer. Thank you, Mr. Chair.
Representative Owens.
Thank you, Mr. Chairman. And Scott, this might be towards you or towards Todd, and thank you guys for sharing your knowledge with us. So help me understand, how big of an issue is this? And are we dealing with people, are we dealing with people that are actually involuntarily committed first? So they get taken in front of a judge, the judge is involuntarily committing them to an inpatient treatment regimen, and then being released pending their more permanent hearing. Am I understanding that correctly? Okay. And then secondly, how big of a problem is this? I mean, doesn't seem like this happens very often, because I hear about people never being able to get into Osawatomie or Larned. So how many people are we talking about on a regular basis?
Well, Representative Owens, for us, on our statistics, like I said, we had 26 patients come in. What we're seeing from Osawatomie, and you're right, many people aren't staying their full session, and in fact, they're not coming back for adjudication. And so they're being released once they seem to be deemed okay or medication is under control. We have no idea how long that's going to be. This puts a safety measure for them that they do have to return back to court if they want their firearms and ensure that safety. I think anytime someone is deemed and has been found, at least with the temporary process, as a health risk to themselves or others, it's probably best suited that they do not have a firearm.
Representative Owens, this is Scott Schultz. I think the main key thing to remember here is this is an involuntary committal, and the courts don't necessarily take this very lightly. They are obviously looking towards an expert, like a community mental health expert, to be able to tell them what exactly is the situation and whether or not this, based upon that assessment, that this individual and perhaps even obviously the facts that came before that, as far as law enforcement contact and why they were contacted, this is, you're taking away obviously somebody's freedom in a civil context and involuntarily committing them to a state hospital. So there are steps in the statute that provide for that, and it obviously has to be, one of the things, there are 3 things that the court can do at the temporary hearing. They can detain the individual and send them, like we've been talking about. They can actually say that the individual's mentally ill and not detain them, or they can dismiss the case. And so when we're getting to that point, if the court, this basically allows the court to do that. It doesn't require them to, but it allows them in cases that are they believe are warranted to be able to enter this particular temporary order.
Thank you for that. And to follow up, Todd, I think you're right. There's absolutely a time and a place for somebody not to be in possession of a firearm. For me, it's understanding that these people are going through an appropriate process to ensure that indeed this is the set of circumstances that would prohibit that from occurring. Because I think that we have seen some other processes that maybe aren't quite so thorough that would allow for that to occur. And so I simply want to make sure that those that are indeed are going through an appropriate process are indeed being found within the statute to be involuntarily committed and things like that. So final question, do we have any idea how often this type of thing occurs? I mean, I see in Todd's County, there were 26 patients total. Scott, do you have any idea on a statewide level how often this occurs or would occur?
Representative Owens, as you can imagine, I think maybe some of you may be asking, why did the Sentencing Commission even bring this bill? Because it's not criminal. We do not have, in response to your question, we do not have data with regard to care and treatment. So, I think as a medium county, in Todd's case, they could probably, my guess is there could probably, KCDA could probably do a survey, not to give them anything else to do, but just if you were wanting to know, volume wise, that would probably be an easy rough estimate if you're wanting to know how many of these actually take place. The other thing would be OJA may have some data on that from their annual report.
All right, thank you. I thought you were here to provide the data because you're the data masters over there at the Sentencing Commission. So thank you, and thank you, Mr. Chairman.
Representative Wheeler.
Thank you again, Mr. Chair. And in full disclosure to Mr. Thompson, I am a past president of the Kansas County and District Attorneys Association and remain an active member of their Board of Trustees. But that aside, my line of questioning here has been sort of as a devil's advocate. Because in this hearing, we have never heard the Second Amendment mentioned. And my concern is, as we go through this, I'm very sympathetic to the danger issues because I've lived through that as a prosecutor, that we provide for adequate due process. So what this bill provides, it provides that at the temporary hearing, where some judge makes a finding that he's mentally ill and needs in terms of commitment, but so theoretically, they then go into a commitment, either in a state hospital or with the consent of a local mental hospital place in the hospital. And then they, as you suggest, they're released frequently. And there is no adjudication. It's been mentioned. So there's no court finding based upon actual evidence of the people in the treatment center as to his present condition. So if they release him, is he safe? And it's upon him to go back to the court and petition that he get his guns back. And I'm using he generically. I know that's not a universal term anymore, but I'm doing my best. What's the standard there? There's no mention. The judge just says, oh, I think you're crazy. That's what's really happening here as a devil's advocate. And we have to be careful with this. And I am very, very sympathetic to the danger involved of people living in the same household. But it has to be done right. So my question is to Mr. Thompson. In your opinion, sir, does this cover all the due process issues that I have just mentioned?
Your Honor,
And I would also follow up
sorry.
with a question. When a person is released, sir, from a hospital, state hospital or local, why is there, excuse me, I'm sorry about that. Why is there not an adjudication? Why is there not? Explain it to the committee.
Representative Wheeler, I believe you know, I respect and I honor our Second Amendment as much as probably anyone in the room. And I agree with you in your respects. And when I was informed about this bill, I took that with a lot of consideration because we don't want to take people's rights away for the firearms for any reason but what we probably already statutorily have. I believe this falls within those grounds. If you remember the temporary custody hearings, their appointed attorney at that time and testimony is actually presented usually with the care and treatment finding. So we're asking for it after that hearing, which is, again, it's a temporary hearing, but it still goes through a full right and process that they have to go through before they're even found to be involuntarily committed. And, you know, that's a pretty high standard to be involuntarily committed. And to do that, I think we go through almost all the steps that you would probably expect as a normal bench trial. And in bench trials, we do have cases where we take firearms away when they are convicted. Now, again, this is not the same because this is a mental health issue. But in this mental health issue, this is a very targeted mental health issue, as you pointed out. It's not about alcoholism and it's not about other organic or anything like that. It is technically about people who are a harm to themselves or others. And that's probably the most serious risk we would face with someone with having a firearm is harming a self or others. And I illustrated an example of that, as well as illustrated examples others that had faced crime or criminal conviction or criminal penalties while also facing a care and treatment. And that's why not only do I think that this rises to the level that is necessary, you're right, they do have to come back to the court. And we would prefer probably them to come back to be adjudicated. But, you know, our hospitals are as Representative Owens had mentioned, they're deplete. We don't have enough room. We have people waiting months and months to get in. And I believe that at this point, they're probably kicking them out quicker than they should be. And I would wish that they would be able to come back, get adjudicated and shown that they're completely healthy, but that's not what we're seeing. And we're not seeing those adjudications. And thus we're stuck with this quagmire and why we need this legislation.
So summarizing that, my friend, the deficiencies in the state system under mental health causes a person to lose his or her Second Amendment right.
Well, I would posit that they get representation of an attorney, they get representation, and they can provide the opportunity to present evidence to show that they would not need to be temporarily held.
The adjudicatory hearing?
Not just the adjudicatory, but the temporary hearing.
If everything is settled in the temporary hearing, why do we bother with an adjudicatory hearing?
Well, that's what we're finding, and that's why that's the loophole that people are getting around. Because if you adjudicate them and they're adjudicated found to be a care and treatment, then they actually do lose the right to the firearm. Right now, we're still allowing them firearm, even though we're finding them that they need to be involuntarily committed. It's a chicken and egg argument, if you ask me.
Mr. Chairman, I'm going to cease my questioning. I appreciate the liberty of the chair.
Representative Neely.
I'd just like to read, I looked up the definition of what a red flag law is. They are state laws that authorize courts to issue a special type of protection order allowing the police to temporarily confiscate firearms from people who are deemed by a judge to be a danger to themselves or others. Is that not what we're talking about?
Are you directing your question to anyone in particular? guessing by their silence, neither one would like to answer that question.
I believe it's a little bit different than the law enforcement taking the firearm. This is about the court doing that.
Any other questions for the proponents? Representative Burris.
Thank you, Mr. Chairman. Just to follow up, does not the court take the firearms through law enforcement personnel?
This is Scott Schultz. That most likely probably would be the mechanism by which that would be the case.
Not seeing any other. Oh, go ahead, Todd. No, that wasn't Todd. Was someone trying to speak? Or am I just hearing things? Because that could happen at this point in the day. Okay, not seeing any other questions. I do not have anyone listed as a neutral. Are there any neutrals? I don't have any opponents either. Is there anyone here in opposition? Do not see anyone. We'll close the hearing on House Bill 2095. Committee, that's it for today. We will enjoy your evenings. We'll see you tomorrow. Thanks.